While we're waiting for that to happen, we are going to go back to the live trial against Hankison. Brett Hankison was law enforcement in Kentucky. On the stand now, a witness who was the deputy police chief at the time. Let's go back to court. Oh, we have a sidebar, so we're going to talk over this and talk about what's going on. So let me ask you first, David, Bruno, Alicia Dern, still with me. David, sidebars like this, there have been quite a few of them in both trials that we've been covering in Florida as well as Kentucky. Unusual or not?
Very usual in the cases. Look, there's a couple ways to bring issues before the court. It could be done in limine, which is before the trial, and where there's formal motions filed, and then oral argument where the court makes decisions. And then there's these sidebars that happen at trial. Oftentimes, it's an issue of evidence, where sometimes attorneys will make the objection on their feet, state the legal ground. Some attorneys will try to get a speaking objection, what we called, or try to make argument on their feet. But oftentimes the court wants the arguments to be made at sidebar, outside the presence of the jury. Oftentimes when judges are determining evidence and whether or not evidence is admissible, or questioning or areas of questioning are admissible, we don't want the jurors hearing it, because if the evidence is stricken, if it's not admissible, if it doesn't come in, we do not want the jury hearing it, being biased by it. That is why we use sidebars. Sometimes the jury is brought into the jury room, and the attorneys can make oral arguments in front of the court where we can capture those on the cameras. Other times they're at the sidebar if they're short, and that's what they're doing right there. They're addressing evidence, and they're probably making argument. The judge will determine what's admissible and what's not.
Right, and David, textbook description of all of that. And in my experience, sometimes attorneys would want it on the record, sometimes off of the record, but you had to do that so that the jury couldn't hear. But the other piece of that I have to mention, Alicia, I don't know if you were watching with us earlier today, we were covering the trial in Florida, and to David's point, the attorney would constantly object and say, objection, that video shouldn't be shown, or objection, I don't know why they're doing it this way. That's not a proper objection.
No, it's not. And it's really aggravating when you're on the other side of that, those what we call speaking objections. And sometimes when you're dealing with a lawyer who's doing that on the other side, you'll ask the court to instruct the lawyer to stop with the speaking objections and to simply state the grounds of the objection for the record. I have on occasion had judges who tell us up front that they do not allow sidebars at all because of concerns about the jury and the time it takes to remove the jury from the room, or concerns about the jury overhearing. And so they will require lawyers to argue things for the record on the breaks. That's the minority of judges because of exactly the point earlier that you do not want to have evidence on the record that cannot, be unrun.
Right, absolutely. All right, it looks like court is back. The sidebar's done. Let's go back to the courtroom.